All right. Well, hey, let's go ahead and get going. We'll have some others come in here as we get going because we've got quite a few who've registered for this today. But we get to talk about the wonderful world of collections here in the great state of Texas. We'll be touching base on federal law as well, but it really is kind of the collection process for both single family communities and condominiums. For those of you that do not know, my name is Clint Brown. I am an equity shareholder. I lead our POA division, and I've got board certification in both community association law and single family residential law. That just means that I had to take a bunch of tests and get and pass, and I basically live, breathe, and eat community association law. So exciting stuff here today on collections. I am, of course, an attorney. Attorneys love to give their disclaimer, so here you go. The information presented today is based on the law as it exists today, October 23rd, 2024, and it is presented for educational purposes, does not constitute legal advice. As always, I love hypotheticals and what if scenarios, but again, if you need some formal legal advice, please consult with your management team and or your legal counsel so that they can give you some good legal advice. Obviously, legal advice, legal counsel, but some of the collection processes can be answered by your management team. With that, let's go ahead and rock and roll. Let's get going. And as Kyle mentioned in the chat, if you've got a chat, please feel free to type it in. We'll be monitoring it. I try to monitor it while I'm going through our presentation as well, so that if something comes up while I'm on a topic, I like to press pause when able to answer the question or give the attorney answer with, well, I don't know. So here's our agenda today. We're going to talk about collection-related laws, and then we're going to get into the pre-litigation single-family collection process. Single-family communities are governed by Chapter 209 of the Texas Property Code. And then we're also going to talk about condominium collection processes, much shorter of a process and a lot quicker from point A to point B. And then finally, this doesn't happen too terribly often, but I'm going to talk about ourselves. I'm going to talk about our law firm and what we do that is different from other law firms here in the state of Texas, and why that matters to you as a board member or community manager. So let's get going. Okay, collection related laws. I'm going to do a quick pause, kind of a 101. Most of you on this call may know this, but there are two main types of community associations here in the state of Texas for residential. Type number one is what's called a single family type community. And it's where basically you own the dirt. You own the lot that your home is situated upon, and you've got a mandatory obligation to pay assessments. Assuming you meet those criteria, you are subject to Chapter 209 of the Texas Property Code. The other type of community here in the state of Texas we see a lot of is condominium communities. Condominium communities are unique in that you do not own the dirt that your home is situated upon. Rather, it is owned in common by all the owners within that condominium regime. And there's two vastly different collection processes that take place depending on what type of community you are. A third type, which is a really weird one, is your townhome. A townhome community can be either a single family community or a condominium community, depending on how the documents are worded. So if you're a townhome, you've got townhome in your name, and you just don't know what type you are, reach out to your management team. He, she, or they should be able to give you a fairly quick answer as to whether you're a condo or single family. Hopefully, most of you already know. So single family law is federal law, which is the FDCPA. Attorneys love their acronyms. That stands for the Federal Fair Debt Collection Practices Act. And then we've got Chapter 209 of the Texas Property Code. These are some of the statutes that we're going to be going through under Chapter 209. For condominiums, again, FDCPA, It applies across the board. And then we've got 82.113 statute under the Texas Property Code we're going to be looking at as well. Okay, so single family collection. This is a new law, 209.0094, that came into effect in 2023. This is an important law because it relates to an association that likes to file notices of lien. I say like because most of the time for single family communities, there is no statutory requirement to file a notice of lien, and your declaration does not require it. Regardless, many communities like to do it. They believe that it helps in the collection process. Maybe the management company implements some sort of form of notice of lien because they believe it helps in the collection process. But legally, most of the time, filing a notice of lien is not required, number one. Number two, filing a notice of lien does absolutely nothing to stop the statute of limitations. Well, what is the statute of limitations to collect assessments in the state of Texas? For single family and condominium, it is 4 years. 4 years is the statute of limitations, which means you get to go back 4 years of assessments to collect. If it's outside of the 4-year statute of limitations, your debt collector, your law firm, cannot collect unless an owner does what's called a reaffirmation of debt, which is possible, but it doesn't happen too terribly often. It's, most law firms try to get that reaffirmation. You've just got to do a lot of disclosures to make it clear that there is no legal obligation to reaffirm unless they want a payment plan. And then you've got a little bit of wiggle room there. But again, 4 years, the statute of limitations, and filing a notice of lien does nothing to stop the statute of limitations. So let's assume you're a single family community and you want to file a notice of lien. Oh, and I've got a question. This is a good one. Does a notice of lien help in the case of a sale to block the sale without clearing the debt first? Legally, it does not block the sale. However, many title companies will either not close or basically exempt that lien from their title commitment, their title coverage, unless the lien has been cleared prior to the sale. Because, you can still sell a property with a lien on it. It just follows the property and the new owner is responsible pursuant to that purchase. But again, what happens when there's a sale? Almost all of the time, if a title company is involved, they contact the management company for what is called a resale certificate. When that happens, a management company will provide a statement of account. So most of the time, even if you file a notice of lien, the title company is going to contact the management company to get that resale certificate and to get the statement of account. So you get paid even if you don't have a notice of lien on file. But very good question. Is a notice of lien same as filing a lien? Yes, it is. And again, for single family communities, I'm saying most of the time it's not required because it is governing document driven. A lien gets filed for most communities here in Texas the minute the developer files your declaration, your deed restrictions, your CC&Rs, all interchangeable terms, and it's what's called a continuing lien. Now, when they file that declaration, the lien is zero. But after sale, let's say I stop paying, my lien activates. It's a continuing lien. It's always active, but it goes from zero to whatever that dollar figure is. There is no notice of lien requirement most of the time. So getting back to our hypothetical, let's assume that you are a notice of lien filing community. You like it. You believe that it does help with the collection process. And you've either instructed management company working with one of their internal law firms, or you've got your own attorney filing notices of lien. What happens? Well, we've got this new law that says this. Before filing a notice of lien, you must send 2 letters with waiting periods after each. The first letter, you can send it however you want to. You can send it email, you can send it regular mail, and it just says, hey, you owe money, please pay. No certified mail requirement. After that letter, you must wait 30 days. So letter number 1 gets sent. email, regular mail, however. Then you wait 30 days. After the 30 days expires, you send a second letter that must be certified that talks about the delinquency. Again, notice of delinquency, now it's sent certified mail. After that letter gets sent, you have to wait 90 days before filing a notice of lien. So 30 plus 90, the whole time period, start to finish, is 120 days. Here's where we get to do a little bit of double dipping in terms of statutory compliance. What letter do single family communities send before they give a file to an attorney? The Chapter 209 letter. That letter is sent certified mail. Well, there's your second notice right there. So you just have to make sure you send a first notice before you send your second notice. And you have to make sure there's that 30-day period between those two letters. For most management companies, they send at least two letters before they give it to the attorney. And most management companies, between the first and second letter, wait 30 days. And that was before this new law took effect. So you were already complying with this law. Now, when you refer it to the attorney, you just have to make sure there is that 90-day wait period between the certified letter and when that attorney files the notice of lien. That attorney, he, she, or they should know about this law and should make sure they're complying with it before they file the notice of lien. Number one. Number two, if you are a lien filing single family community, I strongly recommend you give the attorney on referral your first letter and your certified letter, because any attorney that practices in this area is going to want to see that first letter to make sure you are in compliance with the new law from 2023. That single family condominium, no requirement whatsoever, unless the governing documents say otherwise. So if you want to file a notice of lien for a condominium, you can follow your normal practices and comply with the declaration to the extent it has any requirements in it. Okay, so let's keep cruising. All right, so the management company, and again, let's talk single family and condo. Let's assume they send 2 to 3 letters, and we're going to do single family first, and then the management company sends their certified letter, their Chapter 209 demand, and they wait how many days? 45, right? They've got to wait 45 days now for that 209 letter. So they wait their 45, and maybe on day 50 they refer it over to the law firm, right? So law firm gets it. Most a law firm should do this when they get the file. They should run bankruptcy, run a title report. Run bankruptcy to make sure they're not in bankruptcy, the owner. Run a title report to make sure the owner is still the owner. Run a probate to make sure the owner isn't deceased. And run Social Security. Again, there's a whole system just to make sure everything is in order. Look at CAD, look at the county appraisal district to make sure all the addresses match up. And assuming all that is correct, owner's name is correct as well, that law firm will typically send what is called a validation of debt letter. This is a federal mandated letter. It helps to provide what's called a kind of a level of protection for the law firm, for the association, and for the management company. It's called a safe harbor provision. And there's stuff you've got to include in the validation of debt letter, and you've got to give, we use the 45-day rule, again, because the law is a little unclear if it's date of receipt of letter or date sending the letter. So we add a little bit of extra float room to give the owner plenty of time to pay off of the validation of debt letter. That letter gets sent, 45 days expire. Next step is basically what's called it's one of 3 things. It can either be a lien notice letter. So again, that's when a community association wants to file a notice of lien. You send kind of your second demand letter along with a notice of lien filing saying, this is what we're filing, or hey, this is what we've already filed. Or you can send a final demand letter, which is just kind of a more strongly worded letter to the owner saying this is your final chance to pay before we initiate a foreclosure lawsuit. Or you may be sending what's called an inferior lien letter. And an inferior lien holder letter is a 61-day letter. So you have to wait 61 days after sending. So 45 days you've got to wait after sending, 15 to 30 days wait after sending, and then final demand 15 to 30 days after sending, and then the inferior lien letter 61 days after sending. What is an inferior lien? So again, quick sidebar, picture a totem pole or a pyramid. When there's a lien up here and a lien down here, if the higher lien forecloses, it wipes out all liens below it. So association lien is here. We run what's called a full title report. It's a title report that looks for any and all liens associated with the dirt. And if there are any liens below our association lien, we are legally required to send those lien holders a notice, a demand letter, and it's 61 days for them to pay or contact us for more information. And it's because if our lien forecloses, it wipes out their lien. So it's important to send that junior lien holder letter, and it's legally required, right? So we don't even have the option, even if we wanted to avoid sending that lien letter. Now, throughout this whole attorney process, right, sending these two demand letters with all the time frames in between, an owner's got the right to communicate with us. And it's funny, they have a right to opt out and say, hey, you need to stop contacting me. And if they tell you that verbally or via email, all you can do for communication with them is to tell them that you acknowledge receipt and are ceasing communication. And you also say the only communication you will receive from us are those that are statutorily required. Otherwise, you do not communicate with them. No phone calls, no emails, no letters. You're done. You basically pass go, collect $200 and proceed directly with a lawsuit if you've got an owner opting out of communications. The other funny one is called the 7-7 rule, and it's communication no more than 7 times within a 7-day period. Most of the time, that's not an issue. The weird situation is when you've got an owner maybe entering into a negotiation with a law firm, right? And there's a lot of back and forth phone calls, emails, trying to get a payment plan worked out. Many times you'll exceed that 7-7 rule requirement. I'd make an argument they've kind of waived it because you're actively engaged in resolving the debt, right? It's not like we're contacting you 7 times within a 7-day period, just making threats and getting nasty and borderline harassment. Regardless, that rule is there. Now, you send all of these letters, right? All of these letters, nothing happens, or owners refusing to pay, whatever the case may be. For single family, the next step usually at that point is authorization to proceed with filing a lawsuit. A lawsuit I could spend 2 hours talking about, but just know that a lawsuit is not foreclosure. A lawsuit is not foreclosure. Rather, it is something you file in the court system to get a judge to look at the facts and either say you win by default because they didn't file an answer to the lawsuit, or you win as a matter of law because you are the association, they bought within the association, and they owe assessments, and you're entitled to foreclose. So a lawsuit is to get a judgment that allows for foreclosure down the road. Additionally, even if you get a judgment, there is no requirement to post the property for foreclosure based on the judgment. So, I do get a lot of questions from managers and board members concerned over, hey, if we authorize this, does that mean we're foreclosing next month? No. So there's still a lot, many more steps that have to take place. There's going to be many more opportunities for the owner to resolve the situation, get the debt paid up, do a payment plan, something along those lines. Okay. Now, this is a very good question. And one of my colleagues addressed something similar for fines a few months ago. And I'm going to try to address that as well as collection process. And I'll take a quick pause. 45 days after second notice was mailed. Yeah, so the final letter you get sent, and you legally need to wait 45 days from the date of sending. But again, I like the float of 5 days to make sure we're interpreting the statute correctly. The other question, can a judgment be filed of record in the county real property records? Yes, and that's something that most attorneys strongly recommend doing. It is what's called abstracting the judgment. So you get an abstract of judgment, which is a one-pager, and then you record the abstract in the real property records where the property is located. Very good question. Another question, if a judgment is approved in favor of the association, what are collection options other than foreclosing on the judgment? Well, you can engage in what's called post-judgment discovery, where you send a lot of discovery requests to try to locate assets. If that doesn't work, you may be able to garnish their bank account. In Texas, you can garnish bank accounts, which is essentially freezing an owner's bank account and drawing monies from that bank after a court orders release of those funds to the association through a writ of garnishment. So those are some options that you can look at. And again, it's something to think about, but our biggest tool, our biggest remedy is to post it for foreclosure. And I'll reiterate the fact that you could literally pull the foreclosure the day before foreclosure, if that's what the board wanted to do. So even if you approve posting it for foreclosure, sorry, lots of F's there. There is no requirement to actually proceed with foreclosure. The board could make the decision to pull it the day before, or even the morning of the foreclosure. I like the day before. Morning of's a little too tight in my book, but again, different options that you can think about and discuss with your attorney when and if the time comes. And I say if the time comes because our law firm, we do a lot of collection work for a lot of our clients. And I would say less than 1% of all accounts referred to our office ever make it to foreclosure. Most of the time you get a pay in full, you get a payment plan, or there's a bankruptcy, something else happens where we never make it to foreclosure. So please keep those percentages in mind. There are other law firms that are likely similar in terms of foreclosure. So very high success rate on collecting the amounts due and owing at some point in that collection process. So getting back to our discussion, 209.0051, and again, we're still talking single family here. 209.0051 of the Texas Property Code, H as in Harry, says the board may not, unless done in an open meeting for which prior notice was given to owners, consider or vote on ... initiation of foreclosure actions. And the other one I'm going to add in here just to kind of clear the air, levy of fines, or I think the word is fines. That may be it. Consider or vote on fines. Consider or vote on initiation of foreclosure actions. So what does that mean? Well, the most conservative approach is every time you want to refer one or more account to a law firm to either to collect on a foreclosure action to proceed with foreclosure, or you want to levy a fine, every single time you have to properly notice that and vote on it during open session without revealing the identity of the owner that you're fining or you're referring to the attorney for a foreclosure action. That is the most conservative approach. That is the slam dunk approach. You are in great shape. And what you would do in those instances is you would refer to the last 4 digits of the account, you would vote on it, and then you would proceed. Or let's say you've got 5 collection accounts that are ready to go to the attorney to initiate the foreclosure process. And again, foreclosure process doesn't mean we're foreclosing tomorrow. It means we're sending demands, we're filing a lawsuit, we're getting a judgment, and then we're finally posting it for foreclosure. And you either refer to the account numbers, the last 4 digits of the account number, or maybe you have a dollar limit. Maybe all 5 of those accounts are over $1,000 or $1,500 or $2,000. And you say, I make a motion that all delinquent accounts above $2,000 be referred to the law firm to proceed with collection. collection action, including but not limited to foreclosure. That is the most conservative option. That's going to get you well in compliance with the law. Now, another option that a lot of communities consider is adopting a policy, a collection policy that says, hey, look, if there is any delinquent amount, we are authorizing referral to the attorney to initiate foreclosure actions. And then that allows you to use that process so you're not having to approve every single collection action. And there is a good argument that complies with 209.0051. Now, this policy or this resolution has to be noticed, right? It has to be properly noticed to your owners, and it's got to be voted during open session. When you notice it and vote on it during open session, guess what you're doing? You're complying with the requirement for initiation of foreclosure actions. Same thing with fining. You adopt a fine policy that says, hey, look, if there is a violation, this is the fining process we are going to follow. You properly notice when you send out your agenda, consider and vote on adoption of fine policy, or consider and vote on adoption of collection policy with foreclosure actions, and you vote on it during open session, you are arguably complying with 209.0051H. I say arguably here because there is no case law that we're aware of that specifically addresses this question, which is why the most conservative approach is to do it on an individual basis, but there are other options available to communities. I strongly recommend you get with your management team and your council to talk about that, and then just make an informed decision. Okay. And then again, you can discuss this stuff during executive session, but I don't recommend you vote on it in exec. I really think you need to vote on that during open session to comply with the law. And again, you don't refer to the owner's name or address, refer to the last 4 digits or 5 digits of their account, or maybe use a dollar figure so that you cover the 5 accounts. They're all over $1,000, something along those lines. Question: if a board escalates accounts to the attorney and we use verbiage, and I'm going to say in the motion, include up to but not limited to foreclosure, those minutes are sufficient later at the time of action of foreclosure. We don't need to hold another meeting just for the foreclosure step. Is that correct? The answer is yes. If you vote on referral to the attorney to initiate collection action, including and up to foreclosure, you have voted on it. You've voted on the initiation of a foreclosure action during open session that's been properly noticed, and you can use those meeting minutes down the road. Now, is the law firm still going to come back to you before filing a lawsuit and say, board, do we have authorization to file a lawsuit? Absolutely. Our law firm does that unless we have a specific directive stating otherwise that comes from the board. Because again, the pre-litigation process, at least with our law firm, is very cheap. The minute you file a lawsuit, those attorney's fees go up because you've got court action, court costs, all that kind of things. So it's important to make sure the board knows, what they're approving. So, but very, very good question. Thank you. If they have a fine policy, does the board still have to meet? Again, there's an argument. The answer is no, as long as you properly adopted the fine policy, number one. And number two, as long as the fine policy complies with the new law change that happened in 2023, which says you must give a schedule of fines. So make sure you've got that new fine policy. If you don't, there's a problem there. You need to get with your counsel ASAP to try to get that fixed. Okay, let's talk some pitfalls before we get into condo collection. Sorry for those condo boards or managers out there. I promise I'm going to get to you soon. So collection pitfalls, this applies to single family and condo, and partial payment complication. Accord and satisfaction is one of the reasons why we do not like it when management accepts partial payments when the account is at the law firm's office. What happens when the check that they send in says payment in full for all amounts due and owing in the little memo, and the association cashes that check? Well, there's a good argument that owner has satisfied what's called accord and satisfaction. And it basically says, hey, if you cash this thing, you're agreeing that our debt has been settled in full. So be very careful with acceptance of partial payments. We recommend not accepting them, notifying the law firm when the account is at the attorney's office. It's no longer with the association. It is now with the law firm. So watch out for accord and satisfaction on partial payments. All right, another partial payment problem. Number one, timing of payment. What happens if the partial payment gets paid in January? So we've got an annual assessment of $500, and an owner sends in a payment for $500, and it says 2025 assessment. Our recommendation is to accept that payment. Why? Because it is not delinquent. They're paying timely for the 2025 assessment. But assuming the partial payment is outside of that period, again, our recommendation is do not cash. Now look, the partial payment may cover 90% of the debt. Our law firm's recommendation is to accept that payment, apply it according to the law, and then you'll just have a 10% amount remaining on the ledger because you've gotten paid 90%. It's kind of the philosophy of let's not spend more attorney's fees on 10% of the original debt. Let's get this accepted. Let's get it closed at the law firm, and then y'all can try to collect that remaining 10%. And then again, there's an application of payment statute we'll go into here in a sec, but there is a way to apply payments that an association has to do if the association accepts the payment. So we'll go into that here in a minute. Limiting instructions, restrictive endorsement. So that's kind of accord and satisfaction. Acceptance equals paid in full. So you've really got to be careful with that. Okay, priority of payments, single family community. I'll talk condo here in a minute, but single family community law says this. If you, the association, receives a partial payment, you must apply it in this order. Delinquent assessments first, current assessments second, third-party collection costs or attorney's fees, other attorney's fees, fines, and then other amounts. That is the way you have to apply payments. The one caveat I would argue is when an owner sends you a check in January for $500 and says this is for the 2025 assessment. I think there's a very good argument that you should apply it to that assessment because it is not past due yet and you need to comply with the owner's request. But let's go through the hypothetical here. Okay, owner owes $2,000. $1,000 is assessments, and the other 1,000 is management company collection costs, late fees, interest, and attorney's fees, right? So 1,000 in assessments, 1,000 in that other stuff. Owner makes a $1,000 payment. Association applies the $1,000 payment to the account. What happens? Well, assuming there isn't a default under a previous payment plan, the association must apply all that $1,000 to assessments. What does that leave us on the account? Well, it leaves $1,000, but that $1,000 is made up of attorney's fees, interest, management company costs, late fees. Do you think a judge is going to like an association filing a lawsuit on all that stuff? Hey, judge, here's me in court. Judge, I'm seeking a default judgment. Yeah, they paid all the assessments, judge, but they still owe me for attorney's fees and interest and collection costs. It's a very hard thing to do successfully, especially depending on the county you are in. Judges, unfortunately, aren't the biggest fan of community associations many times. They don't understand that we're a nonprofit and we have to have these funds to operate, what many cities do, what we have to provide our community. Regardless, it is what it is. We do the best we can to try to argue in front of a judge. But just remember that when you accept those partial payments, you're really eroding our core right, and that is the collection of assessments. That's why we tend not to recommend doing that. Now, that's single family. That's what we recommend. For condominiums, there is no law on how to apply payments. So what should a condominium do? They should adopt a priority of payment policy that says, hey, look, if there's a partial payment made, here is how it's going to be applied. And you have attorney's fees up there, you have the management collection costs, late fees, and you have your assessments down towards the bottom of your priority of payment policy, so that if a partial payment is accepted, our assessment delinquency amounts are still preserved. Okay. Where does interest for assessments fall on the schedule? So again, we just went through those, and interest is below assessments. Back to, okay, so that was single family. Let's talk about condominiums. Condominiums have a statutory lien. 82.113 is a statutory lien. It says an assessment levied by the association is the personal obligation of the owner and is secured by a continuing lien on the unit and on rents and insurance proceeds received by the unit owner relating to the unit's, owner's unit. So this also goes on to define what an assessment is. It's dues, fees, charges, interest, late fees, fines, collection costs, and attorney's fees. So it is almost anything under the sun is considered an assessment under 82.113. Now, if your community was, if your community's declaration was filed on or after January 1st of 1994, you're good to go. This is the law of the land. If, however, your declaration was filed before January 1st of 1994, you have to make sure there isn't a conflict between this wording and what your declaration says. So again, your attorney, as long as they practice in this area and have some good experience, they'll know that. They'll know what this legal requirement is. Again, subordination, right? I was talking about the totem pole earlier where there's a lien below us. Our lien can wipe out their lien. 82.113 gives us a statutory lien priority, and it says our lien is basically superior, has priority, is the tippy top against all other liens except, and then it gives this laundry list: a lien for taxes and other governmental assessments, which is another statute says that, a lien or encumbrance that's recorded before your declaration is recorded, and that doesn't happen too often. And then finally, a first deed of trust lien recorded before the date on which the assessment sought to be enforced becomes delinquent under the declaration, bylaws, or rules. So think of pretty much, it's called a purchase money security interest, a PMSI loan. It's when you take out a loan to buy your unit, your condominium unit. That's the most typical example of that one. Okay. So when a person buys into a unit, again, this is a statute, 82.113, the unit owner grants to the association a power of sale in connection with the association's lien. What does this mean for condominiums? It means for a condominium, you don't have to file a lawsuit to foreclose. You could, if push comes to shove, and I don't recommend this, you could arguably foreclose your condominium lien in as little as roughly 30 days. It could be that quick. Do I recommend that quick of a foreclosure? Most of the time, no. Well, Clint, why not? It's our remedy. We should use it, because you need to get the low-hanging fruit first. If an owner can pay the debt through a management company sending a letter, management company needs to send a letter. If they're going to pay when an attorney sends a letter, let the attorney send the letter. It's a lot cheaper than having to go through that foreclosure process. So let's get it resolved with the most effective and efficient way possible, and that is sending those letters first. Now, look, there are exceptions to every rule. I'm just saying this is a general recommendation of our law firm. Okay, so again, we can foreclose judicially or non-judicially through that power of sale, so you don't have to have a lawsuit filed. I'll do a quick caveat for communities whose declaration was recorded prior to January 1st of 1994. You've got to review your declaration because it could say something different. And if it does say you've got to file a lawsuit, well, then you've got to file a lawsuit. So just make sure, again, this is something your attorney should be doing every single time that they are representing you. So but that is the rule. Costs of foreclosure, attorney's fees can all be added to the account. And if an owner does not believe the foreclosure sale was proper for a condominium or single family, they can file a lawsuit to basically argue that it was a wrongful foreclosure. Something was wrong. But that lawsuit cannot be just because the purchase price was lower than the fair market value. It doesn't work that way, and the law says it doesn't work that way. Okay, condominium owner default. Again, just some different foreclosure options here. We'll keep going because I want to get to some Q&A for y'all. I don't want to take up all of our hour. Okay. Pre-litigation process for condominiums. As I mentioned, for single family, our law firm and most law firms, well, I can't speak for other law firms. They should do this. They should pull the last deed. They should do their bankruptcy search. They should look at the county appraisal district. They should, what our law firm does is we completely and utterly remake the ledger. I'll talk in a minute why that's important, but we redo the ledger, make sure it's all clean and valid and interest has been levied properly, and then we send our validation notice. Again, things we do, let's say that letter gets sent, nothing happens, and we're ready for our final letter. Another thing we start working on is what's called an appointment of agent for sale. If this hasn't already been done, the board has to appoint us, and this is condominium, the board has to appoint us as trustee to conduct the foreclosure. So we take off our debt collector hat, we put on our trustee hat, and we actually sell the property at a trustee sale. So again, that's something done throughout the process. Nothing happens. Y'all sign the appointment of agent. We're now asking, hey, do we have authorization to post the property for foreclosure? Answer is yes. We attend the sale. And again, less than 1% of the time, it only makes it to the foreclosure doorsteps less than 1% of the time. So very, 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 very rarely does it happen. All right. So we go through the whole process. We talked about single family where we send our letters, we file our lawsuit, we get our judgment, and then we post the property for foreclosure, asking the constable to conduct the sale. For condominiums, we send our letters and we post the property for foreclosure where the law firm acts as the trustee. We're kind of like the constable selling the property. We're just acting as the trustee there. Property sales. For single family communities, we've got to give a notice to the owner saying, hey, look, your property got foreclosed on. Same thing with condos. The big difference between condos and single family for the right to redeem is for single family, an owner has 6 months to redeem the property. And we tell the owner that, hey, look, you have 6 months to get the property back from the foreclosure. You have every right to get it back. You just have to pay all amounts due and owing, reimburse whoever bought the property, pay for any assessments, pay for any of the costs that purchasing owner paid, and you get your property back. For condominiums, same scenario, roughly the same wording. The only difference is a condominium owner only has 90 days after foreclosure. So 3 months after foreclosure to redeem the property. So single family, 6 months, condominium, 3 months. So keep that in mind. Okay. this is the part where we talk kind of about our law firm's process and what we do. And these time frames are rough estimates. Most law firms have peaks and valleys in terms of referrals, so that if you're in peak referral season, which is late spring into summer, this timing may be a little bit longer because we're dealing with a lot, just more referrals, right? But day one, it gets referred. Day 2 to 7 is when all those searches get done that we talked about: account setup, pulling last deed, bankruptcy, probate, ledger input. And again, I said I'd address this again. Why is it important to recreate an association's ledger? Here's the problem we run into for the clients we represent. For whatever reason, sometimes this happens. Interest is not calculated properly. Interest cannot be compounded. It's typically only chargeable against the assessment. So you can't charge it against interest, right? Compounding. You cannot charge it against collection costs, late fees, management fees, administrative fees. Interest can typically only be charged against the assessment, number one. Number two, the interest rate has to be proper. If it's not proper, we've got to adjust the interest rate. And we tell the client all of this. Why is that important? Why is it important? Well, because number one, federal debt collection laws say this. They say you can only charge what you are authorized to charge. And so if we're not charging interest right, or we're compounding interest, or levying fees we don't have authority to levy, that's a lawsuit for the association, management company, and law firm. So we have to make sure we are doing it right, which is why it is so important to have a proper ledger that complies with the governing documents, state law, and federal law. So again, that ledger input does take time because we're having to recreate a ledger, but it protects the management company, us, the law firm, and of course you, the association. Very important. After all that's done, somewhere within day 3 to 8, we send our validation notice, and we give basically 40 days, 45 days for them to pay us on that first demand. That doesn't happen, right? We check in back with the association, make sure they didn't get a payment. Sometimes they do. And assuming all that's correct, we proceed with our next step. And now we're in, day 58 because of the timing. We run what's called that full title report, where we look for all lien holders, right? Every single lien holder. And we get all that back. It gets reviewed by an attorney. If there's a junior lien holder, we've got to give them 61 days. If there is no lien holder, it's anywhere from 15 to 30, depending on the documents. Typically, we do 30, but sometimes it's 15, and we send that final letter. Again, it's either 61 or 15 to 30. That's day 60. After that, we've got to wait either another 30, so 90, or we've got to wait 61, which is in the 120 range. Owner doesn't respond. We've sent these letters. We go back to the association and say, hey, do we have authorization to file a lawsuit? It's time for us to file the lawsuit. Once we get that back, we proceed with the litigation process. And again, I could spend an hour talking just litigation, so we're not going to get into the nitty-gritty as it relates to litigation. So that's single family process. Condominium process, much, much, much quicker, because that single family process only got us to filing a lawsuit. For condominiums, we could, and again, I say this could, I don't recommend unless there's a unique situation, we could post for foreclosure as early as 30 days after referral. Again, I don't recommend that for the reasons I referenced. Let's get those low-hanging fruits and get it resolved cheaply and quickly. Regardless, there are exceptions. So we've got our time frame. I've already gone through all of this. And just know that after we send our letters, we could be posting the property within 90 days. If we follow our normal process, you could have it posted within that 3-month period. Because condominiums are different, there is no lawsuit requirement. Okay, for all of these processes, and again, this is where I give my RMWBH stick. Our law firm is different from many other law firms in that we are a true flat fee firm. So it's not just our schedule where you see our fees for demand letters. We don't charge for emails, phone calls, status reports, none of that. So if an owner calls us 15 times or the board follows up on something, it's all included within our flat rate. We reserve the right to exit the flat rate when things get a little sideways. Sometimes they do. And sometimes we have to go that route. Most of the time we don't in the pre-litigation process, but it is a true flat fee process pre-litigation. Why do we do this? Number one, the phone calls, emails, little fees here and there, they add up for the community very quickly and very significantly. And so we want to avoid that as a law firm. Additionally, it's time for us. We have to input those times, those charges. We then have to review those times and charges, and then we've got to invoice those times and charges. So to be efficient for you, the community association, and our law firm, we've kind of gone pure flat fee for pre-litigation. And it also allows you to budget a little bit better on attorney's fees so that you know your attorney fee budget a little bit better. For our first demand letter, our success rate is in the 60 to 70% success rate. Most of the time, again, there's always outliers, but if you refer 10 accounts, 6 of them get resolved on the first letter. And whatever that flat fee is for that first letter is what you get charged. We close the account and you're done. Then you've got 3 to 4 left. We send that final letter. That final letter efficiency drops down to 20% to 30% based on the data we've run. So it's not as successful. But again, maybe we get another resolved so that now you're only dealing with 2 or 3 accounts left that you have to look at, either a condominium foreclosure initiation or filing a lawsuit. So again, very successful in terms of percentages and payment, all that kind of stuff. And we just got done. We're actually wrapping it up now on attorney fee comparison. We like to compare our attorney's fees to other law firms in the various markets. And right now we're sitting at anywhere from 1.5 to 2% to 2x, not 2%, 1.5 to 2x cheaper than other law firms on attorney's fees. Because again, we're trying to be efficient and effective for y'all and getting it resolved quickly. So that's it on my shtick. I promise I'm done. I just kind of wanted to talk about that. So we can move on the RMWBH difference. We kind of talked about all of that. And kind of conclusion before we get into our Q&A, having those adequate controls in place. I didn't get to hit on this, but most management companies do this. When it goes over to an attorney or a law firm, they flag the account. They put a little flaggy on there. They wave around. No, it's a virtual flag. Ha, bad attorney joke. It gets flagged when it's in the legal process so that you're not accepting partial payments, so that you know when an owner calls trying to pay the balance in full, you need to refer him, her, or they over to the law firm to proceed with interacting with them to try to get it resolved. Know that many times owners, unfortunately, they'll play the system, right? So they got that 209 letter that says X, and then they get our law firm letter that has another $200 added for attorney's fees, and they're like, well, this one's $200 cheaper. I'm going to try to pay this one. Just know that, when it's flagged, the management company will send it back to counsel to try to get that resolved. Training and education, what you're here for today, is so important so that you understand the laws and how they apply to you as either a manager or as a board member. Training with board members, again, board members, managers, very great. And then understanding the options available on the market and the types of services that are truly being offered. Just understand sometimes y'all know this, contracts. It applies to law firms too. One law firm are apples on costs and the other law firm are oranges. Just do your best to try to understand and get an apples to apples comparison, and know that our law firm is as a true flat for pre-litigation stuff. So, all right, great. Let's get into our Q&A. Let's scroll up here. We've answered a lot of these. Good. If you make a partial payment on Zelle, just treat it like a partial payment. It needs to be rejected unless it's within, that higher percentage, 80, 90% paid. Well, then maybe you accept it. We've answered that. Owners keep going delinquent. That one's been answered. Can we get a copy of the PowerPoint? Absolutely. That'll be sent out. The recording will be available on our website as well and on YouTube. Super exciting. Get to listen to an attorney again. Yeah, all been addressed. Yes, we do serve all of Texas. We're in all the major metroplexes, and we're all over. Most of the time, you've got a law firm office really close, and so in the event you need interaction with a lawyer, maybe I'll use me as an example. I'm in Austin. I've got a Dallas client, and the client wants me there at their next board meeting. You don't get charged for me going from Austin to Dallas, right? It's from our Dallas office, so it really helps knowing that you've got a full team. We've got more board certified attorneys in the state of Texas than any other law firm as it relates to community association law. So we really do pride ourselves on kind of trying to be the best at our business and providing that good service. A condo HOA has a threshold of $1,500 to go to collection company equity experts. Ooh, equity experts. I think you'd probably need to speak with equity experts on that. Sorry, I can't get into that one with that company. Recently been told that attorneys can accrue their legal fees, maybe. So basically, on attorney's fees, as long as the attorney is going to collect those attorney's fees from the client, the association, there are sometimes options to do a delay pay that doesn't violate the law. Basically, if that's something you need to look at because of your financial health being really, really bad, maybe speak with your counsel to see what kind of options he, she, or they can offer. Does the board have to vote on fines if there's a fine policy in place? I addressed that one. Single family flat rate. So again, it's like a schedule of fees. If anybody's interested in that, they can reach out to our law firm. Just go to our website, and we're happy to give you that info. Oh, there we go. There's my QR code. You can use the old phone and QR code it to send me that question. Happy to give you more info. Happy to how to handle an unimproved lot that are not worth the collection and legal costs. Well, that's a good question. I guess I would need to know more, right? What's the collection amount? What's the assessment rate getting levied every single year? And what's the amount in year 4? Maybe you've got to start in year 4. And when does it convert from you not meeting your standard of care, right? Because a board has an obligation to collect monies, to collect amounts due and owing to the association. And if you repeatedly don't do that job, when is enough enough and you violated your standard of care? So it can be a scary situation. Please reach out to your counsel and management team to get some advice and come up with a strategy so that you're meeting your standard of care as a board. Really good question. Does your firm also help HOAs on other matters like amendments to bylaws, lawsuits by homeowners? Absolutely. So we've got a division that all they handle is insurance defense litigation. So when you get sued and insurance kicks in, our law firm is on panel counsel for a lot of different insurance carriers, which is why we get so good at offering corporate advice, because we see these problems pop up and then we fix them on the corporate side so they don't affect our current clients, or we reduce the chance of getting a lawsuit filed. Y'all probably know this, but you could be doing everything 100% right and still get sued, unfortunately. What is the difference between judicial and non-judicial foreclosure? So a judicial foreclosure is when you have to file that lawsuit. and you get a court to award you a judgment. It is longer. It is a longer process. It is a more costly process, but the law requires it for single-family communities. There's something called expedited foreclosure that could be an option, but most of the time it costs the same amount of money as a judicial foreclosure. Non-judicial foreclosure is what condominiums use usually, and that's the one where you do not have to file a lawsuit. You don't have to go to court. You can post within that 3-month period, as I mentioned, sometimes 30 days. I don't recommend 30 because we want to be effective and efficient, right? Let's be cheap where we can be cheap for the ownership. What do you do with a property where the owner is deceased and none of the heirs want any part of the property? They've said, stop communicating with us. Well, the board may have to turn over a new leaf and initiate foreclosure. That's possible if the person has been deceased for more than 4 years. So get with your counsel so that he, she, or they can give you some options. What is your take on a ledger that shows a balance forward? Oh, that's a good question. So you've got to have a breakdown on the balance forward, right? You really should know what the balance forward is composed of. And if you don't have that information, what we do is we treat it as not collectible, as subject to the statute of limitations. We kind of treat it as kind of SOL, statute of limitations. And if an owner wants a payment plan, we get them to reaffirm that debt. So it's not like it's bad debt. You've got to write it off immediately. There are options to collect it down the road through a payment plan and what's called a reaffirmation of debt. But again, federal law, state law, very clear. You cannot collect balance forward amounts that you don't have a breakdown on. So you really need those breakdowns. It's important. And most managers will tell you this, but when you go from management company A to management company B, that is one of the most important things you have to have. You've got to have those owner account ledgers because you do not want the balance forward. You want to have that breakdown. How late does the account need to be before we start the collection process? Again, really each community is different. Your management team, if you have one, should be able to give you a good idea. And if you need to lean on your legal counsel, he, she, or they can help get you a process set up. And then we're 3 minutes over. I'll answer the last one and we'll close it. Owner has 2 properties in the same association. Do we have to treat them as separate collection processes or can we combine? Yeah, I think there's a good argument you can combine. Again, the general rule is I'm okay with doing a combo. You just have to be mindful of the process. And for our law firm, that kind of takes it out of the flat fee, but it's still cheaper than having 2 separate accounts. But it takes a little more diligence on the part of the paralegal and the attorney. And I just want to say thank you all so much for showing up today. I hope I didn't have any nods out there in the crowd, and I appreciate y'all all showing up. With that, I hope you enjoy your Thursday and enjoy your weekend. Goodbye from RMWBH.